The legal definition of a contract and the difference between the two is that a contract is a legally enforceable agreement. You can have an agreement that's not legally enforceable, and if it's legally enforceable, then it is a contract. And of course, you want your agreements to be legally enforceable, right? So what are some examples of agreements that might not be enforceable? Examples of agreements that might not be enforceable: an agreement signed by a minor or a person who's incompetent, an agreement that doesn't have certain terms that are material to the contract. You're buying a house and it doesn't have the address of the property that you're buying, or it doesn't have the amount that you're buying the property for. Generally, to have an enforceable agreement or a contract, it requires three things: an offer, acceptance of the offer, and consideration. Consideration is a pretty deep technical legal concept. It's usually not something we need to be concerned about. It just means that somebody is either giving up something or getting something in exchange. So really we focus on offer and acceptance, and consideration can be almost anything at all. We're going to move on to a little bit more of a practical side from that more law school type lecture and say, what is my process when I'm reviewing an agreement? It's pretty straightforward, and I think this is a pretty common way to look at things. And I hope this is something that you as entrepreneurs can start doing for yourself, although of course, know your limits and be sure to get help when it's warranted. If I'm reviewing an agreement, I'm really doing these things. The first thing I'm doing is just reading it. I'm looking to see if it makes sense. I'm reading it over, and if there are any questions, this is presumably an agreement that has been presented to you or to me, I'm asking questions. The person who's presented it should be able to answer those questions. And many times you'll find that they won't be able to. In some cases, they haven't read it. In some cases, they've cobbled together agreements from prior deals that they've done, and it doesn't necessarily hold together, or it isn't necessarily appropriate for the situation. So don't be afraid to ask questions and get them answered to your satisfaction. One thing that you really need to pay attention to is whether the agreement is the entire agreement. Does it reference other terms and conditions or other documents that may or may not have been given to you? That is overall the basic process for reviewing an agreement. And on the flip side, let's say you want to prepare your own agreement. The basic process when it comes to writing an agreement, I would say the three things that I would focus on first is, what are the material terms? What is it that this contract is about? What are my obligations? What are the other parties' obligations? I try to prepare my contracts in plain English. There's no need for any magic words or special legal language. It's really, clarity is the most important part in these contracts. You want to look at this as though somebody else who isn't a party to the contract would be reading it and trying to interpret it down the road. And less is more. If you don't need to say it, don't say it. Of course, make it as long as it needs to be, but no longer. A typical outline for a contract, if I'm starting from scratch, would have these elements. It would have the basic economic or financial terms that are important to the deal, in that the buying the house situation. What is the price that we're paying and what is being transacted? If you're talking about for your services, what percentage of a commission or payment are they agreeing to, or what hourly rate, or what flat fee are they agreeing to, or are you agreeing to? What are the obligations for each party? What are you agreeing to do? What are they agreeing to do? What rights do you have, if any, and what remedies do you have? And then there's the legalese, really the back end of the agreement that most people ignore, that really does matter to some degree. And I'll say, you want to make sure that you've got an entire agreement clause. You're writing an agreement. You want this to be the entirety of the agreement between the parties. Term and termination, you want to define what the length of the agreement is and how and when it gets terminated, under what conditions. It would be helpful in most cases to have some type of a dispute resolution provision, whether that's, we're going to say it's going to Montgomery County, Pennsylvania if it has to go to court, or any state court or federal court in Pennsylvania or wherever it is you are, or if you want to agree to some type of commercial arbitration or mediation, which is in some circumstances called for and can be preferable, although expensive. And what I'll say is one of the keys that I make sure is in every agreement that I review for clients or write for clients is a limitation of liability. The limitation of liability is an important clause that I would look to have in every one of my agreements. Recommend that you strongly consider, and if you want, if you either email me or I can post into the Facebook group my suggested language for a limitation of liability clause. It really is just kind of a backstop to say that at the end of the day, whatever a normal way to apportion liability would be to say, whatever the value of this contract is at the end of the day, I shouldn't have to pay you back or pay you any more than the value of this contract is. You don't want to bet the entire company over a $5 contract. And this also is important execution. When it comes to executing the contract, you want to make sure you're signing as an agent of your company. This is to protect your personal liability. This is the situation of being concerned that your company is a separate entity and a separate person from yourself, so that you're not tagged as an alter ego of your company and you don't get your corporate veil pierced. So always make sure that if you're signing an agreement for the company, you're signing as an agent of the company. You have your company's name. That is actually who is contracting, not you individually. Just like with most things, I think there are 3 levels that I would place it as. There are some things that are do-it-yourself, some things where you want a professional, and some things where you want a specialist. And I think for most contracts, you should have the confidence that you can do it yourself, and also use the judgment and discretion to know when you should get help from a professional or a specialist. And that's really it for my lesson portion.